So let me take this to Nalini because that's an important point. The court, Nalini, also raised a very pertinent point. What is the definition of a religious character of any place? This itself has not been defined in the Places of Worship Act 1991. This is very clearly open to interpretation on the basis of evidence gathered and submitted before the courts at this point of time. Because, Kapil Madan was saying, if prayers were happening in 1947, this suit would not be required. If prayers were happening in 1947, but were stopped in 1991, who's in violation of the Places of Worship Act then, Nalini?
Gaurav, that's a very interesting point you make, because usually when we talk about the separation of powers, what we say is that it's the job of the legislature to make the laws, the job of the executive to implement the laws, but it's the job of the courts to interpret the laws. So whenever there is something missing in what has been written down, it is the job of the court to read into it and find out exactly what the definition is. So like you said, the Allahabad High Court has very categorically said in its judgment that what a religious character is itself not defined under the Places of Worship Act. So in a situation like this, it falls upon the court to go ahead and first of all interpret what religious character is. And that's precisely the reason why the court has said that this suit is not barred by the Places of Worship Act, because until and unless A, the court defines what religious character is, and then B, applies that definition and decides whether the religious character of the Gyanvapi complex, because, and we're now calling it complex, because the fact that it's been a mosque or a temple is something that the court has left open to interpretation, is something that can only be determined by the court. Now remember, Gaurav, this is a trial that was stayed back in 1998. Yes. And since 1998, the trial has not continued. So that's why this verdict is even more significant, because it's finally given a green light for the trial to go ahead that was stayed way back in 1998. And not just a green light, the court has said in its order that this trial needs to be concluded expeditiously, because this is an issue of national vital importance, is the words that they've used. And they've given a deadline of 6 months to the Varanasi court to conclude this trial. Having said that, there is no doubt about the fact that the Muslim parties will approach the Supreme Court, sure, challenging this Allahabad High Court order. They've already said it in a bite earlier today, yes, that they will fight till their last breath. So it all remains to be seen what the Supreme Court decides before we can take a final word on this.
Oh, absolutely. But as on date, as facts stand as on date, the ASI survey will happen to find facts. The Masjid committee was opposed to the survey, and their plea stands rejected. The ASI survey, Mr. Madan, was happening on the orders of the court. But Desh Ratan Nigam asks that question, why is it that one side wants facts to come out, the other side does not want even a survey to be conducted, or if a report is submitted, it should be in a sealed cover and facts should not emerge. Mr. Madan, is that fair?
Gaurav, I think, when you look at the arguments made by the other side, the Muslim side, they have primarily raised the point that, the suit is barred by the express provision of the law. And if I would, give a technical term to our viewers, there is a provision under the CPC which we use, which we call Order 7, Rule 11, which is used. Which is used where you want to get the suit out at the initial stages. Now, it's a technical provision. It's a technical provision. This is, rarely the person invoking this provision succeed, because what happens is, in this case, is that the court who's deciding the matter, yes, has to look at it only the documents presented by the plaintiff, the person who is seeking a relief from the court, and not any other document. It is again a settled provision of law.
But that's been settled. That's been settled. My point is, respond to Desh Ratan Nigam saying that one side wants facts to emerge. The Muslim side, according to Desh Ratan Nigam, does not even want a survey, an ASI survey, a scientific survey, or when the report is submitted to court, those facts should be made public. In your appreciation, why, sir?
Gaurav, I think I am not representing any of the petitioner or the respondent here. So whatever is the legal strategy adopted, I mean, as a lawyer, you would try and ensure that you win the case, and you win the case as early as possible. And this is one of the legal provision which you had in your, prima facie in your favor, which you
Okay.
could have invoked, and you could have, won at the initial stages. And Mr. Nigam would agree with me. He's also a lawyer. When you are appearing from the respondent or the defendant side, your strategy is to get the closure, get the plea rejected at the initial stages. So it
Nalini,
appears to me,
okay.
a legal strategy. It appears to me a legal strategy that, let's win it at the initial stages. Perhaps, the court has not found favor with the argument by
Fair
the
enough.
Muslim side, and that's the reason why you have an order of where they have
But the fact still
ruled in
remains
favor of
because
the Hindu side.
the Muslim side, why does the Muslim side not want facts to emerge in this case now that an ASI survey has happened in parts of that Gyanvapi complex? But Nalini, does this then pave the way for an ASI survey of the Wuzu Khana where the Hindu side insists there is a shivling and the Muslim side claims it's a fountain? And I want to show those images. The Hindu side says it is a shivling there. The Muslim side says this is a fountain. ASI survey there, will it ascertain facts?
Well, Gaurav, that's a very interesting and tricky question because the Allahabad High Court verdict today has categorically said that during the course of the trial, if the Varanasi District Court feels that a further survey is required to be conducted for the determination of the facts of the case, then it has the authority to go ahead and do that. But at the same time, this comes with a very big rider, which is not mentioned in the judgment, but which is something we know through the history of this case as we've seen over the course of the past few years.
Okay.
When the matter had reached the Supreme Court regarding the ASI survey, there is a Supreme Court order in place that had allowed for the scientific survey to happen, but had specifically said that the Wuzu Khana area needs to continue to remain being sealed.
Yes.
So in light of that order already having passed by the Supreme Court, any scientific survey that needs to be conducted has to come only after approval of the Supreme Court. There cannot be any survey that can be conducted in contravention of that order. So there is no doubt about the fact that this matter is eventually going to end up in Supreme Court. So there should not be any additional legal hurdles for there to be a decision on that. But any survey has to be conducted only with the green light being given by the Supreme Court itself.
And